The BC Civil Liberties Association has filed a lawsuit against Canada's secretive cyber spy agency, Communications Security Establishment Canada, or CSEC. It says the agency's sweeping surveillance of Canadians violates the Charter of Rights and Freedoms. Jennifer Hall is in the newsroom with the latest. So, Jennifer, tell us about this suit.
Well, Andrew, if you go to the website of the BC Civil Liberties Organization, here's what you'll see. Stop illegal spying. CSEC can conduct secret and unchecked surveillance of Canadians. They call it secretive, expensive, and out of control. And that's what led to this news conference today, announcing that, in fact, they are launching a lawsuit against the organization, saying this highly secretive agency, CSEC, monitors and collects private information of Canadians every time a Canadian makes a cell phone call or logs onto the internet to write an email. They say CSEC can at present do all of this without a warrant, and they call that unconstitutional, saying that is what has to be stopped. Further, it argues that the group, the information it can gather is so specific, it can even track where a cell phone call is being made from. In essence, as they describe it, creating a digital trail of individuals' private lives. Here now is one of the lawyers behind today's lawsuit, speaking to what he thinks the ramifications could be, really to the psyche of Canadians if this kind of unchecked spying is allowed to continue.
Such untrammeled spying will cause Canadians to censor themselves on matters that are perfectly legal but involve personal, business, political, or the intimate details of one's life for fear that such details will be intercepted by the spy. This is what lawyers call the chilling effect on expression.
And Andrew, it's safe to assume that this highly secretive organization, CSEC, was virtually unknown to most Canadians until a couple of weeks ago when it was revealed through leaked documents, thanks to Edward Snowden, that former National Security Agency contractor in the U.S., who leaked these documents. And this time we found out that, in fact, there were allegations that this organization, CSEC, was spying on Brazilian mining interests, and that created an international furor. So one of the lawyers today, to sum up, saying the function of the spy is to spy. And when there are no effective checks, it will go far beyond that. That, it says, is a threat to our democratic freedoms. That is why this afternoon in the BC Supreme Court, Andrew, they filed a lawsuit against CSEC.
All right, Jennifer, thanks.
You're welcome.
My name is David Martin from Martin Associates here in Vancouver. We've joined this challenge because evolutions in both communications and surveillance technology have leapt ahead of the law. While Canadians now communicate and access information utilizing a large variety of devices, powerful computers have empowered agencies such as CSEC to intercept and store previously unimaginable amounts of private communications and data. We've all followed the debate that's occurred in the media. I think it's safe to say that a consensus is emerging that the control and governance of CSEC must be reformed. A former CSE chief has recently suggested that CSEC be required to report to a committee of Parliament, as is done in the UK. U.S. law already requires judicial control, although the rigor and effectiveness of that control in that country is yet to be determined. This case asserts that effective judicial control is constitutionally mandated in Canada and must be adopted. Why judicial control? Judicial control is firstly independent. Our courts are not subject to the day-to-day political considerations and pressures that the Minister of Defense, who currently issues these authorizations and directives, is subject to. Secondly, our courts are effective in carrying out this function. They have the institutional capacity to weigh and balance competing interests between security, privacy, and liberty. They do that every day. They are familiar with the warrant requirement and its administration, and they're particularly suited to administer the rule of law under which all of us hope to be governed. Finally, judicial control is constitutionally mandated. in Canada. And this isn't a policy decision that's open to debate today. The division of power between the three branches of government in Canada, Parliament, the Executive, and the Judiciary, was decided more than 30 years ago when the Constitution Act was repatriated and the Charter of Rights was entrenched. These constitutional instruments are the foundation of our democracy. Judicial supervision of when and in what circumstances state agencies can invade our privacy interests is mandated by Section 8 of the Charter. It guarantees the privacy rights of all citizens by virtue of its guarantee that everyone has the right to be secure against unreasonable search and seizure.
The BC Civil Liberties Association says the Canadian government is illegally spying on Canadians, and the group is launching a lawsuit against Communications Security Establishment Canada, otherwise known as CSEC. For more, I'm joined by Kaylee DePuma, one of the lawyers involved in drafting the claim. She's live in Vancouver. So Kaylee, lay it out for us. Why do you think CSEC violates the Charter of Rights?
Well, right now, today, CSEC can intercept the phone communications and email and text communications of Canadians when they are communicating with someone outside of Canada. CSEC can also collect private metadata information that is produced automatically anytime a Canadian is using their mobile phone or accessing the internet. And there's no judicial oversight, no court or committee monitoring CSEC's interception of these communications and information, and we say that that is unconstitutional. It must be stopped, and that's why the BCCLA has filed this lawsuit today.
All right, so just to be clear, what you're saying is for CSEC should not be listening in on phone conversations that Canadians make from Canada, even if they go overseas or across our borders.
What we are saying is that if CSEC is going to have that power, it should be monitored by a court, a parliamentary committee, or some reasonable oversight mechanism to ensure that the rights of Canadians are being respected.
All right. So what if it's a case of national security and this needs to be kept secret? Would you be comfortable with it being monitored but also kept secret?
I think that there's always going to be a balance to be struck between national security and privacy concerns. Right now, the law isn't balancing that properly. There may be aspects of CSEC's operations that will always be secret. We're talking about spying. But the Canadians trust their government to protect their safety and their privacy. And that trust is not a blank check. We say that the government is getting it wrong now.
So what is it that you think Canadians should be most worried about? Because some people will listen to what you're saying and they'll say, well, if I'm not a terrorist or I'm not involved in anything questionable, then maybe I don't care that much that CSEC is monitoring calls to thwart a potential threat against the country.
Right. Well, Canadians should know that this case is not about what they might be hiding from their government. It's about what their government might be hiding from them. And we say that Canada is not a nation of secret laws, that Canadians ought to be able to access and understand the laws that impact on their rights and freedoms. And in order to do that, CSEC needs to clearly state who they are watching, what they are doing with our information, and how they are handling it.
Do you think the BC Supreme Court will consider hearing the case?
Absolutely. We are confident that the BC Supreme Court will hear this constitutional challenge, and the onus will be on the federal government to prove to the court that what is happening now meets constitutional standards.
Kaylee, good to speak to you today. Thanks very much.
Thank you so much.